For the first time in almost 3 full years, the U.S. Supreme Court has finally agreed to take on a case related to January 6 prisoners. In this case, it can have huge ramifications, not only for the plaintiffs in the lawsuit, but also for almost everyone else who has been charged with obstruction of Congress, which includes President Donald Trump himself. Now, let me break down for you exactly what this case is all about. To start with, the Department of Justice keeps a special page on their website which is devoted to listing out the indictments that they've issued in relation to what happened over on January 6th. And if you scroll through that list, you'll find that the most widely charged felony is obstruction. Specifically, almost 330 defendants, alongside President Trump himself, have been charged with corruptly obstructing an official proceeding, with the official proceeding being a joint session of Congress that was convened to certify the Electoral College votes on January 6th. And this obstruction charge is a felony. However, many of the defendants are arguing that the underlying statute that they're being charged under is actually being completely misinterpreted by the federal courts. Because you see, the specific law that these individuals are being charged under, this law right here, the Sarbanes-Oxley Act of 2002, otherwise known as the Corporate and Auditing Accountability, Responsibility, and Transparency Act. Now, this law was passed by Congress back in the year 2002, shortly after the financial fraud at Enron and WorldCom were exposed to the public. And essentially, this law was meant to close up some of the accounting loopholes which allowed companies like Enron to perpetuate massive fraudulent schemes. The law has a number of provisions in it, making it illegal to do things like destroy evidence, to impede federal investigations. It provides certain protections for corporate whistleblowers. And then also relevant to our discussion, this law has an entire subsection related to obstructing an official proceeding. Now, this particular subsection, it came about directly as a reaction to what happened over at Enron. If you remember, Enron's auditor was actively destroying documents that were potentially incriminating to the company. But at the time, the law was such that there was essentially a loophole where the state could only prosecute people who were persuading others to destroy evidence, but the state could not prosecute the people who were actually destroying the evidence themselves. The people who were actually committing the act could not be prosecuted. That was the loophole. And so this new law, it fixed this particular loophole by defining obstruction very, very broadly. And it's exactly this provision in this law that has been used to charge January 6 defendants. For your reference, here's exactly what the law says. Quote, "Whoever corruptly obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title or imprisoned not more than 20 years, or both." With the term official proceeding being defined like this within the law. Quote, "An official proceeding includes proceedings before federal judges, Congress, as well as federal government agencies." And so that is the backstory of the statute that's being used to charge January 6 defendants. It was a provision in a 2002 law that was specifically passed to close a loophole in financial accounting fraud, meaning that this is the law which has allowed federal prosecutors to charge nearly 300 January 6 defendants with felony obstruction rather than just misdemeanor trespassing, which is exactly why January 6 defendants have been appealing and trying to get their cases to the U.S. Supreme Court so that the highest court in the land can make an official determination as to whether or not these federal judges' interpretation of this particular statute is correct. The arguments that the January 6 defendants are making is that this particular law, it only applies to the destruction of documents or other evidence, and that any other interpretation of that law is stretching it way beyond what the lawmakers who envisioned at the time of its passage. And while for the past 3 years now, they've been quiet about it, well, just 2 days ago, the U.S. Supreme Court issued an order saying that they've accepted to review the petitions of several different January 6 defendants who are looking to appeal their cases. The January 6 defendants who have been granted an appeal are as follows: Joseph Wayne Fisher, Mr. Jacob Lang, as well as Mr. Garrett Miller. And as you can imagine, these defendants were quite thrilled that the Supreme Court finally took up their case. For instance, the lawyer who's representing Mr. Fisher, he told us here at the Epoch Times that, quote, "We're very happy that the court has decided to clarify the scope of Section 1512(c)(2). Likewise, aside from these 3 defendants themselves, all of the other January 6 defendants as well, they're eagerly looking at the Supreme Court case with anticipation, because how the Supreme Court rules in this case will actually have direct implications in their cases as well. And so, for instance, you have Mr. William Pope from Kansas, who's also being charged by federal prosecutors with obstruction, and here's what he said regarding this case. Quote, "The tide has turned. The Supreme Court taking up the obstruction of an official proceeding appeal is a clear message to the DOJ that government extremism has gone too far, that more than 300 Americans, including President Trump, myself, and many currently in prison, were wrongfully charged. Sadly, the DOJ has, for the last 3 years, used the obstruction charge, which the Supreme Court is now primed to throw out to pressure January 6 defendants into taking bad plea deals. The outcomes of many cases would be far different if not for this DOJ malpractice." Furthermore, as he mentioned here, besides the serious implications for all the January 6 defendants currently in jail, as well as the ones currently on trial, this case also has significant implications for President Trump as well. That's because, as we mentioned at the very top of this episode, over in Washington, D.C., quote, President Trump was charged in August with several counts related to obstruction of the joint session of Congress on January the 6th. A grand jury indicted him for obstruction of an official proceeding, attempting to obstruct an official proceeding, and conspiracy to obstruct an official proceeding, among other counts. And so that Supreme Court case will have direct implications on whether or not the charges against President Trump can actually proceed in a court of law. If the Supreme Court rules that the underlying statute is being misinterpreted by the courts, then very likely these charges against President Trump will be thrown out, which is a point that was made quite clear by defense attorney William Shipley. Quote, the decision by the Supreme Court of the United States today to take up the appeal on the 512 obstruction of an official proceeding case means the Trump D.C. case will not be going to trial. This is the easy way to make that happen without directly acting on the Trump case on an expedited basis. And so there you have it. That is where the case currently stands. The U.S. Supreme Court agreed to take up the case. The implications for all the defendants, including President Trump himself, will be significant. And all the while, January 6 defendants continue sitting inside of a jail cell awaiting their trial, which is really insane if you think about it. For instance, one of the defendants in this U.S. Supreme Court case is Mr. Jake Lang, who has been incarcerated in pretrial detention for nearly 3 years. Think about that. He's been sitting in jail for well over 1,000 days awaiting trial. During that period of time, couples have met each other, dated, gotten married, and had children, all in the span of time that Mr. Lang and others like him have been detained in the Department of Corrections without bond, awaiting trial. That is, if nothing else, very cool. If you'd like to read the full appeal that was accepted by the U.S. Supreme Court, I'll throw a link to the PDF version of it. It'll be down in the description box below this video if you are the type of person that likes to dig into the weeds. And all I ask in return is that as you're making your way down there to the description box, take a super short detour to smash those like and subscribe buttons. Smashing that like button ensures that this video reaches ever more people via the YouTube algorithm, while smashing that subscribe button will ensure that every time we put out a new video, it will hit your newsfeed, well, every time we publish it. And now, let me quickly introduce today's sponsor by showing you this little piece of money. Or rather, I should say that this is fake money being printed into oblivion by those geniuses over in Washington, D.C. And so before they completely obliterate your life savings, what I recommend you do is to convert that fake money into real money, which is physical gold and silver. And the best company to use is the sponsor of today's episode, American Hartford Gold, who also happens to be my own personal gold and silver bullion dealer. They have thousands of other 5-star ratings across the country. They have an A+ rating with the Better Business Bureau. They ship quickly, directly to your doorstep. Their product listings are awesome. They're stacked with great options of gold and silver bullion and coins, and they have amazing customer service. When you pick up the phone and call them, you feel good knowing you support a company that supports the truth getting out into the wider American audience. And so calling them up is a no-brainer. But best of all, if you tell them that Roman sent you, they will throw in up to $5,000 worth of free silver with your first purchase. It's 866-242-2352, or you can simply text the word Roman, R-O-M-A-N, Roman, to 65532. Of course, all their details will be down in the description box below. And now, let's head on back to the studio. Now, lastly, if you enjoyed today's episode and you're just thinking to yourself, man, I just wish Roman put out more episodes every single week. Well, you're in luck, because I do. Over on Epoch TV, our awesome no censorship video platform, I publish anywhere between 1 to 3 exclusive episodes of Facts Matter every single week, usually on topics that are unfortunately too spicy for here on YouTube. And so if you'd like to get access to those exclusive episodes every single week, including a huge backlog from the last 2 or 3 years, well, you can find it all over on the website. And now's a great time to check it out because the Epoch Times has launched their best sale of the year. 6 full months for just a single $1. A 6-month trial subscription for just a single $1. Again, this is the best sale of the year. We frankly do not make any money on this subscription. The idea is just to get you in the door, get you loving the content, hooked on the content, all the videos and articles and infographics and everything that we have on the website. And therefore, you might be a subscriber not just for 6 months, but a year, 2 years, 3 years, several decades. That's the idea. You can, of course, cancel anytime, but something tells me that you won't and that you will indeed be a subscriber for a long time to come. If you want to check out that sale, the link will be right there at the top of the description box below. You can just click on that link. It'll take you to the sale page where you can try the Epoch Times. Again, 6 full months for just a single $1. The link is right there at the top of the description box below. And then until next time, I'm your host, Roman from the Epoch Times. Stay informed. Most importantly, stay free.